What is a contract? A contract is an agreement that the law will enforce. There are 6 elements of a contract. A valid contract must be a meeting of the minds on number 1, an offer, number 2, an acceptance, number 3, consideration, number 4, legality, number 6, capacity, number 5, consent, number 6, writing. An offer is a proposition of a deal. An acceptance is the response to an offer. Consideration is what each party gives or promises. Legality is the subject matter of the contract. It must be legal. Capacity is that they must be old enough and mentally competent. Consent, it must be signed at a free will. And writing is only a requirement for some contracts. Bilateral contract is both parties make a contract. Unilateral contract is one party makes a promise that the other one can accept only when the other party actually does something. Valid contracts satisfy all of the law's requirements. Voidable contracts occur when one party has the right to void the contract. And void contracts means neither party can enforce because an aspect of the contract is illegal. Express contracts, all of the terms are explicitly discussed, and implied contracts, the words and actions of the parties indicate that they intended an agreement. Sources of contract law, common law and the Uniform Commercial Code, i.e. the sale of goods, tangible things that are bought and sold. Services don't need a written agreement because of common law, but the sale of goods does, according to the UCC. Promissory estoppel is a possible remedy for an injured plaintiff in a case with no valid contract when the plaintiff can show a promise, reasonable reliance, and injustice. Quasi-contract is a possible remedy for an injured plaintiff in a case with no valid contract when the plaintiff can show benefit to the defendant, reasonable expectation of payment, and unjust enrichment. Okay. Chapter 12, the agreement, offers and acceptances. Contracts require a meeting of the minds on all material terms of the agreement. Offers, price quotes, letters of intent, and advertisement are not generally offers. Rather, they are invitations to bid or make an offer. The terms must be definite. Termination of offers by counter-offer. Acceptance of offers, there are 2 rules. The mirror image rule, accepting party cannot change any aspect of the offer, and the mailbox rule, once an acceptance is in the mail, a deal has been made. Chapter 13, consideration. What is consideration? Each party to the contract must give or give up something of value to have legal consideration. Consideration can be a promise by one party in return for a promise given by the other party. What is value? Adequacy of consideration. The peppercorn theory, even as something as small as a peppercorn can suffice as consideration. Pre-existing duty is not consideration for a new promise or agreement. Past consideration is not a consideration for a promise or agreement. Settlement of debts, liquidated or unliquidated. Generally speaking, the settlements of liquidated debt, where you know the amount of debt, is not supported by consideration. However, the settlement of unliquidated debt, where an amount has not been determined or is still in dispute, is in fact supported by consideration. What is an accord and satisfaction? If you accept payment for the debt, you cannot go back and ask for more. Then there are agreements not to compete and moral consideration. Chapter 14, legality. Contracts that violate a statute are void. Criminal statutory violations like gambling. Licensing statutes. An agreement with an unlicensed individual is unenforceable by the party who should have obtained the license. The contract is therefore voidable. Restraint of trade. Non-compete agreements. An employer requires that an employee sign a condition of employment that can be enforceable but are disfavored under the law. And there's a 3-part test to non-compete agreements. The type of job must be deemed worthy. It must be really short in length, like 1 to 2 years, and it has to be a small geographical area for customers. And then there's exculpatory clauses, a contract clause that attempts to release a party from any future liability to the other party. Generally, the law disfavors pre-waivers of liability. There's an exception to that, which is bailment relationships when you leave your clothes in the locker at the gym. Chapter 15 is on voidable contracts, capacity, and consent. Capacity is minors under the age of 18 contract is voidable unless the minor misrepresented their age, in which the minor cannot then avoid the contract. Mentally impaired persons, if a person is not able to understand the nature of the agreement, then they are making the contract is voidable. This is certainly the case if a person has a conservator or a guardian who has been appointed for them. And third, intoxication at a high level can render a contract voidable. And then consent, fraud renders a contract invalid. So there can't be any fraud in a contract. There cannot be any mutual mistakes, and sometimes no unilateral mistakes. If the contract is signed under duress or undue influence, it is avoidable. No threats or physical duress, and sometimes even economic duress. Undue influences the relationship between the parties and an improper persuasion by the stronger party. Chapter 16, Written Contracts. Some contracts must be in writing to be enforceable, required by the statute of frauds. A few types of contracts that must be in writing: contracts involving an interest in land, contracts that cannot be performed within 1 year, contracts involving the sale of goods worth $500 or more, contracts to pay the debt of another, marriage, and contracts involving the executor of an estate to pay the debt of an estate. If there is a written contract, the parole evidence rule prohibits either of the parties from introducing other evidence at a trial to contract or add the written terms of a contract. Chapter 17, Third Parties. Normally, only parties to a contract may enforce it. In order to have the right to sue for the enforcement of a contract that you are not a part of, one must generally be a third-party beneficiary to the contract. This means that you must have been contemplated as a third-party beneficiary and actually benefit from the contract. Contract rights are generally assignable unless the contract prohibits it, and most do. Exception: if the assignment is against public policy. Difference between assigning contract rights and subleasing: when substituting a third party for one of the original parties to a contract, the original party must assign rights and delegate duties to them. Chapter 18, Contract Termination. When a party is discharged from further performance under a contract and separates, how perfectly must a party perform under a contract? That's a weird question. Sure. Sometimes the duty to perform arises after a condition is met. Condition precedent arises at the outset of a contract, a real estate purchase, like a real estate purchase agreement, the condition of buyer financing. Condition subsequent arises after a contract performance has already begun, like a insurance policy requiring that a claim must be made within a certain time period after damages occurred. Strict performance is each and every requirement must be satisfied before the other party is discharged and entitled to be compensated. Substantial performance: for most contracts, substantial performance is sufficient to entitle a party to partial compensation under a contract for the performance accomplished to date, subject to the items of performances that remain. Okay. Personal satisfaction of contracts: an agreement that by nature requires the subjective satisfaction of a party, like a portrait being painted for someone. Time of the essence clauses provides that deadlines in a contract are to be construed strictly, and if missed by one party discharges the other party from performance. Like if your rent is due and you're late, your landlord may discharge you. Breach of contract. A material breach is a breach of contract terms that are considered material. An anticipatory breach is by one party immediately discharges the other party from any duty to perform under the contract. Okay. Chapter 19, Remedies. Monetary damages. Direct damages flow directly from the contract and must be reasonably certain. Consequential damages result from the unique circumstance of the injured party in question. Damages must be foreseeable. Incidental damages are out-of-pocket costs resulting from the breach. Other non-monetary remedies are a specific performance, making the breaching party hold up their side of the deal. Injunction is making the breaching party stop doing whatever they're doing that violates the contract. And reformation, court will continue to write a contract if they believe it has. Court will rewrite a contract if they believe there has been a mistake in the writing. Chapter 29, Employment and Labor Law. Employment at Will Doctrine states that in the absence of employment contract, an employee can be hired or fired at will. Employment security contract law. An employee handbook might be interpreted by a court as an employment contract. Common law exceptions to the employee at will doctrine are set forth below. It is a tort of wrongful discharge if a person is fired for these reasons: refusing to violate the law, exercising a legal right, performing a legal duty, supporting social values, whistleblowing. Off-duty activities. In the absence of state statutes to the contrary, employers may have the right to fire employees for off-duty conduct, like smoking. Employers can also test employees for alcohol and illegal drugs. However, federal law prohibits testing for prescription drugs unless the employee seems impaired or at public risk, or the public is risked. Free speech on the job. NLRB laws. No protection for free speech at work. Social media apologies. No protection if you post bad things on social media about your job or do something bad while wearing a company logo. Statutory protections for employees. Family and Medical Leave Act, a federal statute providing for the right of up to 12 weeks of unpaid leave each year for childbirth, adoption, or medical emergencies. Employee privacy. Most states prohibit employees to engage in any lawful activities off-duty, but some courts have upheld smoking prohibitions. OSHA protects employee safety in the workplace and establishes a federal agency to enforce it. Guns. Employers have the right to prohibit guns in the workplace, but in about half the states, bring your gun to work laws prevent companies from banning firearms left by employees in their locked vehicles in the parking lot. FLSA addresses minimum wage, overtime, and child labor restrictions. Workers' comp insurance available to employees for injuries at work. COBRA maintains health insurance for 18 months after termination of